Good afternoon. Welcome to today's podcast entitled Fall or Stumble for Illinois Pension Reform, a summary and analysis of the Illinois Supreme Court's ruling invalidating Public Act 98-599. I'm Mark Vacha, and I'm a member in the Public and Project Finance Group at Cozen O'Connor, based in the Philadelphia office. I would like to begin the program with a few disclaimers. This podcast is for information only. It does not provide legal advice. It does not create a client-attorney relationship, and the information herein is subject to change without prior notice. The podcast is subject to copyright 2015 of Cozen O'Connor, and all rights are reserved. And the analysis, conclusions, and/or views expressed herein do not necessarily represent the position of the law firm of Cozen O'Connor or any of its employees or the opinion of any current or former client of Cozen O'Connor. Listeners should not act or rely on information in the podcast without seeking specific legal advice from an attorney on matters which concern them. Thank you, and now let us turn our attention to today's topic. This podcast has three main purposes. First is to briefly summarize and highlight some of the significant points of the Supreme Court of Illinois' decision filed on May 8, 2015, which was docket number 118585, which struck down pension reform legislation for certain state-level pension plans in Illinois. Second is to note instances where the Supreme Court's decision is cognizant of public finance and bond market considerations. And third is to evaluate what takeaways, if any, can be gleaned from this case and what it may suggest about the prospects for certain pension reform initiatives. Obviously, on this last point, it must be emphasized that this was an Illinois case. Nevertheless, it may provide some perspective on how courts in other states with strong pension protections within state constitutions may react to certain pension reforms. Over the last several years, fiscal pressures and concerns for the state of Illinois have been widely publicized, which, among other things, have included downgrades in the ratings in the state's bonds. One key area of fiscal focus has been the state's pension obligations. After numerous failed attempts to reach consensus, the Illinois General Assembly enacted Public Act 98-599, which became effective June 1, 2014, which was to amend the Illinois Pension Code in numerous respects, including reducing retirement annuity benefits for individuals who became members of four of Illinois' 5 state-funded pension systems prior to January 1, 2011. The state pension fund for the judiciary was excluded from the proposed reforms. Now, members of the retirement systems affected by Public Act 98-599 and groups representing those members brought various actions in state court which challenged the validity of the new law on the grounds that it had violated various provisions of the Illinois State Constitution of 1970. The actions were consolidated in lower state court, and on motions for partial summary judgment, judgment on the pleadings, and to strike an affirmative defense of the state, the circuit court found for plaintiffs declared Public Act 98-599 to be unconstitutional in its entirety as a violation of the Pension Protection Clause of the Illinois Constitution, permanently enjoined its enforcement, and rejected the state's contention that the law could be upheld notwithstanding the violation of the Pension Protection Clause based on the state's reserved sovereign powers. Now, the challenges to Public Act 98-599 focused on 5 features of the legislation that would reduce retirement benefits for individuals entitled to Tier 1 benefits, that is, for members who belong to the retirement systems prior to January 1, 2011. The 5 features were: 1, raising the age at which members under the age of 46 are eligible to begin receiving their retirement annuities. 2, capping the maximum salary that may be considered when calculating the amount of a member's retirement annuity. 3, abolishing the existing fixed 3% annual annuity increase, that is something comparable to COLAs. 4, eliminating certain annual annuity increases under the new formula. And 5, altering how the base annuity amount is determined for purposes of the money purchase formula, which is an alternative to the standard formula for calculating pensions for members of certain of the systems who began employment prior to July 1, 2005. The Illinois Supreme Court addressed 3 issues. First, whether Public Act 98-599's reduction of retirement annuity benefits owed to members of the 4 retirement systems violated the Pension Protection Clause of the Illinois Constitution of 1970. Second, if such violation occurred, whether the law's reduction of benefits nevertheless could be upheld as a proper exercise of Illinois' police power, and third, which was a relatively technical and ultimately less consequential issue, if the reductions could not be upheld, whether the invalid provisions of Public Act 98-599 could be severed from the remainder of the statute and still be given effect. Now, although raised in the lower court by plaintiffs, the Illinois Supreme Court did not address certain other state constitutional challenges raised by plaintiffs, such as impairment of contract claims and violations of prohibitions on taking of private property for public use without just compensation and of equal protection provisions. And the case did not fundamentally really focus on federal constitutional concerns. Now, the Illinois Supreme Court provided a detailed analysis of the Illinois Constitution's Pension Protection Clause and its history and understood purposes. This analysis begins to frame and portend for the reader the Illinois Supreme Court's ultimate ruling. The Illinois Supreme Court commented that in order to protect pensions, the 1970 Constitution took the approach of protecting the benefits of membership in public pension systems, not by dictating specific funding levels, but rather by safeguarding the pensions themselves. The court characterized the Pension Protection Clause, stating that the purpose of the clause and its dual features of 1, mandating a contractual relationship between the employer and the employee, and 2, mandating the General Assembly not to impair or diminish these rights, and that this interpretation has never been in dispute. Now, once it put the Pension Protection Clause into context, the court's analysis was very direct and succinct. The court stated that the issue of whether Public Act 98-599's reduction of retirement benefits violated the state's Pension Protection Clause was easily resolved. The court, noting a prior case, said that it held, quote, that the clause means precisely what it says, close quote, and that if something qualifies as a benefit of the enforceable contractual relationship resulting from one of the state's pension or retirement systems, it cannot be diminished or impaired. In various ways, the Illinois Supreme Court made the point that the state could not rely upon its reserved police powers as a justification to uphold Public Act 98-599. In quoting case law, the court noted that no principle of law permits us to suspend constitutional requirements for economic reasons. The court emphasized that, based on U.S. Supreme Court authority, particular scrutiny of legislative action is warranted when a state seeks to impair a contract to which it itself is a party and the state's interest in avoiding the contract or changing its terms is financial in nature. The Illinois Supreme Court emphasized that in contrast to the Pension Protection Clause, there were numerous instances in the Illinois Constitution of 1970 where particular constitutional guarantees were made subject to the state's authority to step in when public safety and welfare required. Examples of this include the right to bear arms, which was subject only to the police power, the privilege of the writ of habeas corpus not being suspended, except in cases of rebellion or invasion when the public safety may require it, rights of religious freedom, which could not justify practices inconsistent with peace or safety of the state, and the right to a healthful environment, which is subject to reasonable limitation and regulation as the General Assembly may provide by law. The Illinois Supreme Court also emphasized that in the process of adopting the Pension Protection Clause, a proposal was submitted to the convention by the chair of the Illinois Public Employees Pension Laws Commission that criticized the language of the clause on the grounds that it would curtail the powers of the legislature. Moreover, a member of the Pension Laws Commission at the time of the convention had requested that a convention delegate read a statement into the convention record that the new provision should not be interpreted as reflecting an intent to withdraw the authority from the state legislature, quote, to make reasonable adjustments or modifications in respect to employee and employer rates of contribution, qualifying service and benefit conditions, and other changes designed to assure the financial stability of the pension and retirement funds, close quote. However, the court noted that the history of the constitutional proceedings showed that this statement was not put into the record given a lack of support. So thus, the legislative history surrounding the 1970 Constitution indicates a contemporaneous understanding of the Pension Protection Clause as a blunt and unequivocal source of protections for benefits. A third issue that the Illinois Supreme Court dealt with was whether the constitutionally infirm provisions of the legislation could be severed from the remainder of the legislation so that effect could be given to some portion of the legislation. In short, the court held that the objectionable provisions relating to benefits were so integral to the legislation that severability was not realistic. Now, more as a footnote, there were some interesting provisions in Public Act 98-599 that went down with the rest of the legislation, but were not necessarily judged to be constitutionally infirm in and of themselves. Specifically, Public Act 98-599 included a mechanism authorizing pension boards to initiate mandamus proceedings if the state failed to make required contributions to their respective systems. It's interesting that the Illinois Supreme Court made reference to the United States Securities and Exchange Commission's actions versus the state of Illinois. And while there were no matters of law cited from the SEC by the Illinois Supreme Court, the SEC's actions seem to not be insignificant insofar as they framed matters in a way where, at least my impression was, the Illinois Supreme Court was disinclined to give the state the benefit of the doubt on any matters. The Illinois Supreme Court noted that the SEC pointed out that the statutory funding plan's contribution schedule increased the unfunded liability, underfunded the state's pension obligations, and deferred pension funding. The resulting underfunding of the pension system, defined as structural underfunding by the SEC, enabled the state to shift the burden associated with its pension costs to the future, and as a result created significant financial stress and risk for the state. The Illinois Supreme Court further noted and quoted the SEC order and found that, quote, the state's insufficient contributions under the statutory funding plan were the primary driver of this increase, outweighing other causal factors such as market performance and changes in benefits. So in many respects, the Illinois Supreme Court decision showed, if not a lack of sympathy to the state, at least a fairly blunt assessment of the state's shortcomings on 2 points. First, that the state of Illinois' fiscal and pension problems were largely due to the state's own making, and second, that Public Act 98-599 was not a last resort, and by implication, that the state potentially may have been able to come up with a solution that was less burdensome to plaintiffs. The former point is particularly relevant in that, in a colloquial sense, if not a more systematic legal way, the Illinois Supreme Court effectively stated that Public Act 98-599 and the burdens it would impose on present and future pension system beneficiaries could not be justified. This was not characterized as an equity analysis, but had some of the sense of that. In short, the court was saying that the state created more of its pension problem and was not doing everything it could to solve it in an even-handed fashion. For example, the General Assembly may find itself in crisis, but it is a crisis which other public pension systems manage to avoid, and as reflected in the SEC order, it is a crisis for which the General Assembly itself is largely responsible. There I was quoting from the opinion of the court. And then the court further stated, the chief sponsor of the legislation stated candidly that other alternatives were available. Public Act 98-599 was in no sense a last resort. Rather, it was an expedient to break a political stalemate. Now, the case provides a few black-letter law takeaways, but little express guidance as to what type of pension reform legislation, if any, may survive constitutional scrutiny. And although not necessarily breaking new ground, the case emphasizes that benefit calculation formulas are entitled to constitutional protection. The court indicated that its decision was affirming a line of cases that the protections afforded by the Illinois Constitution to pension benefits, quote, attach once an individual first embarks, quote, close quote, upon employment in a position covered by a public retirement system, not when the employee ultimately retires. Now, the following are some cautious observations about the Illinois pension case and what it may suggest regarding future pension law changes to withstand constitutional challenges. While pension laws may possibly run afoul of constitutional impairment of contract clauses, it seems the likelihood of a law being struck down under a pension protection clause is greater. In short, the Illinois pension case suggests that in states with pension protection clauses or other strong protections, the prospects of success for pension reform that reduces economically the benefits for existing pensioners and plan members are not good. This leads to what I would view as the most interesting question from the Illinois decision. Specifically, has the Illinois Supreme Court in its dicta offered any roadmap as to what could be the circumstances, if any exist, where similar pension reform as that proposed in Public Act 98-599 could survive state law constitutional scrutiny. The Illinois Supreme Court statements vaguely suggests at least three conditions or circumstances that should be met before similar pension reform could possibly succeed under some theory of reserve powers or otherwise. But it may be more conservative and proper at this point to characterize these as being necessary rather than sufficient conditions for pension reform to succeed. First, reductions in benefits, which is reform on the expense/liability portion of the financial statements, loosely speaking, should be accompanied by reform on the revenue/asset side. The court specifically noted that the General Assembly could also have sought additional tax revenue. And while it did pass a temporary income tax increase, it allowed the increased rate to lapse to a lower rate even as pension funding was being debated and litigated. Second, pension reforms should be included that manage funding liabilities in addition to those that may reduce benefit levels. The Illinois Supreme Court specifically stated that one alternative identified at the hearing on Public Act 98-599 would have been to adopt a new schedule for amortizing the unfunded liabilities. Third, pension reform may need to be undertaken and justified as part of a larger fiscal scheme. This would serve the purpose of an equitable distribution of burdens that may be able to survive impairment of contract and other concerns. The Illinois Supreme Court quoted the U.S. Supreme Court stating that the U.S. Constitution bars government, quote, from forcing some people alone to bear public burdens, which, in all fairness and justice, should be borne by the public as a whole, close quote. So the Illinois Supreme Court noted that although it is undisputed that many vendors in Illinois face delays in payment, the terms of their contracts are unchanged, and under the State Prompt Payment Act, vendors are actually entitled to additional compensation in the form of statutory interest if their bills are not paid within specified periods of time. The court further stated that this in no way was comparable to the situation confronted by members of public retirement systems under Public Act 98-599, which would have negated substantive terms of their contractual relationships. So in short, the Illinois case could foreshadow one of two things. First, a situation where states have very little flexibility to manage accrued pension liabilities other than biting the bullet and undertaking increased funding and related reductions of other services which are not constitutionally protected. As a reminder, states themselves, unlike cities or counties, do not have the last resort of a Chapter 9 municipal bankruptcy restructuring available to them. And again, that is also assuming that the necessary state law authorization is put in place for those lower levels of government for Chapter 9 filings. Second is a situation where reductions in pension benefits are somehow constitutionally managed and justified, but only in very drastic cases involving comprehensive pension and fiscal reforms where the reductions are viewed as last resorts where fiscal pain is broadly shared. It is not hard to imagine that this would be unappealing to many, including those in the judiciary, in all likelihood, given that such measures would be a form of relief that may come too late, that diminish public confidence in the public sector's honoring of commitments to its workers, and may involve judicial entanglement in public finances, which most courts would prefer to stay out of given the legislative character of such matters. Now, albeit under different circumstances, there are more than a few states where equity in public school funding cases showed how frustrating it can be for all concerned when courts must be involved in fiscal policy matters. At the end of the day, it is difficult to criticize the analysis and holding by the Illinois Supreme Court. Nevertheless, it does not bode well for flexibility for managing pension solvency and liabilities, other than maybe to serve as a further wake-up call that easy and quick solutions are not attainable. So now the Illinois governor's most recent proposed solution to the pension crisis would preserve those pension benefits that have been currently earned, create a new 401k type plan, and ask voters in 2016 to remove language from Illinois' Constitution that protects retirement payments. If constitutional change fails, the governor would be forced to make even bigger spending cuts than he has so far proposed or agree to tax increases, unless another plan emerges that unions could support or the Illinois Constitution would allow. Changing Illinois' Constitution would be tough, as putting an amendment on Illinois' statewide ballot would require a 3/5 vote of lawmakers in the Democratic-controlled House and Senate. It would then need approval from 3/5 of voters or a majority of individuals actually voting in a general election. There is no easy solution in sight for Illinois' pension problems, but all eyes will be on Illinois as lawmakers attempt to navigate through the challenges of funding the state's unfunded pension liabilities over the weeks and months to come. So we thank you for joining our podcast today, and we hope that you will look for future public finance podcasts from Cozen O'Connor in the future. Thank you.